To me, again.
Good morning. Are you Devonta Anderson? And Mr. Anderson, in cause number 23 DCCR 0288, there's a motion to revoke probation filed, and same in 23 DCCR 0290. And what is the announcement?
Your Honor, we don't have an agreement. I believe it's probably best to go through the motion.
Okay. Give me just a second to get those. Can you print the second one?
And I don't know if I have the amended one.
I don't see an amended one.
I don't know.
Okay, I thought we said well together.
I think we'll mix it up.
Okay. I'm good.
Give me just a second to get them both pulled up, printed out. Mr. Anderson, while we're waiting on those to print out, would you, best you can, raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right.
I think they're same violations in each case.
All right, thanks.
Yeah, looks like it. Yeah.
All right, and will your client waive the formal reading of the motions in each case?
Your Honor.
Mr. Anderson, in cause number 23, DCCR 0288, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 24th of 2023 for the second-degree felony offense of sexual assault of a child, and that was a 7-year deferred probation. Is that correct? And in cause number 23, DCCR 0290, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation that same date, October 24th of 2023, for indecency with a child by sexual contact, a second-degree felony, and that was also a 7-year deferred probation. Is that correct? Each of these motions allege that you violated your probations. Count 1 in each motion alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of November and December of 2023, and then January, February, March, April, May, and August of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 in each case alleges that you failed to provide verification of performing your community service hours. Is that true or not true? It just says that you didn't give proof that you did your community service hours that were required. Did you do that?
I did some.
Okay, we'll just put a not true on that one. Count 4 alleges in each case that you failed to complete a substance abuse assessment and follow any recommended treatment plan. Is that true or not true? Count 5 in each case alleges that you provided urine samples April 23rd of 2024, August 13th of 2024, September 19th of 2024, November 25th of 2024, and December 5th of 2024, and then January 30th of 2025 that all tested positive for marijuana. And is that true or not true? Count 6 alleged that you failed to successfully complete an approved sex offender treatment program. Is that true or not true? It says that you were unsuccessfully discharged December 6th of 2024. Okay. Count 7 in each case alleged that you failed to submit to the polygraph examination as required December 6th of 2024. Is that true or not true? Count 8 in each case alleges that you failed to not enter a sexually oriented premises in that you admitted to your Harris County officer that you went into an adult bookstore. Is that true or not true? I'm sorry? Not true? Count 9 in each case alleges that you failed to not use any online services, social media, or anything like that unless approved, in that you admitted to your Harris County officer that you accessed the internet without monitoring software. And is that true or not true? Count 8 alleges in each case that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true in each case to counts 1, 2, 4, 5, 6, 7, 9? Would you, Mr. Hoffpower,
Motion to amend that to 10 instead of number 8.
any objection to that?
Repeat that, Judge?
The number,
Oh, no.
it should be
Okay,
number
yeah,
10
I'm
and it
sorry,
says
yeah.
number 8. Any objection to him orally amending that? All right, so that, I'm gonna change that. In each case. Okay, so did you enter your pleas of true to those counts freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
All right, I'm going to find in each of your cases that you entered your pleas of true to counts 1, 2, 4, 5, 6, 7, 9, and 10 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for a sentencing hearing so that I can get an updated pre-sentence report done, or an updated report done by the probation department. Your attorney will be able to present any evidence on your behalf, and so will the state, and we will come back for a hearing at a later date. All right, you can go back with the bailiff. Unagreed.
The other one I have.
Hold on.
Right here.
All right, we're starting heavy right out of the gate. Probation revocation hearings are no joke, especially when the underlying charges are this serious. Remember, deferred probation means you avoid a conviction only if you follow every rule mess up, and the judge can sentence you on the original felonies. Let's see where this goes.
All right, you're Rebecca Rito? And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Give me a minute to get, I'll have to pull that. Ms. Rito, in cause number 23, DCCR 0928, you're charged with, hold on, let me get to that again. If y'all want to print those other ones, it might be convenient. The next three, 210607 and then 1925. All right, in this case, which is 23 DCCR 0928, you're charged with the state jail felony offense of theft of property with previous convictions from November 21st of 2022. The indictment alleges you were previously convicted of theft September 11th, 2010, September 17th, 2010 in 2 different cases. And then again, October 26th of 2015. And then September 21st of 2021 in 3 cases on that date. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all those prior offenses and convictions true?
Yes, ma'am.
And then in cause number, they printing or do you want me to pull it up? In cause number 23 DCCR 2106, you're also charged with theft of property with previous convictions. The offense date from this one is September 23rd of 2023. It alleges those same prior offenses, and how do you plead to that charge?
Guilty.
And are those prior offense convictions true?
Yes, ma'am.
And did you enter your plea of guilty freely and voluntarily? And because you actually did what they charged you with?
Yes, ma'am.
And actually, that indictment, I said the 23rd day, it has been indicted, it has been amended that the offense date is the 22nd day of September. Does that sound correct? Okay. And then in cause number 23, DCCR 2107, you're also charged with theft of property with previous convictions from October 2nd of 2023. That indictment alleges those same prior offenses, and how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all of those prior convictions true?
Yes, ma'am.
And then finally, in cause number 24 DCCR 1925, you're also charged with the state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges those same prior convictions of theft. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In each of those 4 cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it's my understanding you have no agreement in your case, in any of these 4 cases, and so you're just pleading open to me. Is that correct?
Yes, ma'am.
I want to make sure you understand your cases are set for trial to begin with jury selection next week. You have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me, and is that what you want to
Yes,
do?
ma'am.
Sorry to interrupt, Judge. The state has filed a motion to accumulate. We will be asking the court to accumulate those cases to the extent the law allows.
Okay, because they're all different offense dates, correct? Or at least,
Some of them are, Judge.
I think they are, nope, they're all different offense dates.
So we will be moving or asking the court to accumulate those sentences.
And have you gone over that with your client?
Yes, Your Honor, she's aware that the state's asking for the charges to be stacked.
I guess part of my issue with this is, let's say I do something that Ms. Rideau doesn't like, and then she has the ability to appeal, and I don't guess there's really an appealable matter, but you never know. I don't want to waste a bunch of time and then us be coming right back here, but
And Judge, I've looked for the path of least resistance to resolve these cases. We are in the situation we're in because it's defended.
no, I don't disagree. Well, we'll get where we'll get. All right, so you understand that I can give you anything from probation up to 24 months, up to 2 years on each of these cases,
Yes, ma'am.
and I can stack those sentences on top of each other. Do you understand that as well?
Yes, ma'am.
And you want to go forward with these pleas and get the sentencing on these done. Is that correct?
Yes, ma'am.
Okay.
In addition, Your Honor, my client has asked, and I know the response to the court given the prior answer, but I am required to ask that the court, she's asking the court waive pre-sentence investigation on these and proceed with sentencing. She also would like to be released for her, I believe it's daughter's
Yeah,
graduation.
like Saturday from Westbrook. So.
State's opposed to that, Judge.
No, that's not happening. No. All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history, obviously there's a substantial amount of history, and so I want all of the information. So we will get a pre-sentence report done in all of the cases, and I'm not doing anything with the bond other than potentially raising it to make sure that we're where we need to be when we need to be. So, that being said, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Rideau is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning, so you never know. You guys will know today after docket what the trial order is.
One final thing, if I may, on the tampering, Judge, it's filed as a third degree, but I filed a repeat offender notice seeking to enhance it to a second degree, given the defendant's previous robbery conviction. So I just want to make sure that all of that's.
Why did you put the tampering on me when you put the death on me?
Look, we're not, this isn't a conversation.
I'm
It,
confused. I'm sorry, yes, ma'am.
it doesn't matter, and they didn't put anything on you.
I mean, that's what I'm saying.
Okay, listen.
I don't understand how is it tampering? I mean,
That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of a second degree felony, which is between 2 years and up to 20 years. Do you understand?
yes, ma'am.
Okay, and so I will number that case for trial for next week. All right, and you go back with the bailiff.
Thank you, Judge.
Thank you. I'll let y'all know as soon as,
This is a critical legal moment. When he pleads true to those violations, he's essentially admitting he broke probation terms that alone gives the judge legal grounds to revoke probation and impose prison time. The only reason he's not being sentenced immediately, the court wants more background before deciding how severe the punishment should be.
docket's done what the trial order is.
Thank you, Your Honor.
Yes, sir. Good morning, sir.
Good morning.
Are you Traylon Martin?
Yes, ma'am.
And Mr. Martin, in cause number 25 DCCR 0270, you're charged with the third-degree felony offense of obstruction or retaliation from January 29th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And what is the offer that's been made?
2 years TDC, Judge.
And so, the state has offered, if you want to enter a plea of guilty, a 2-year term in prison, which is the minimum. You have every right to reject that and have your case set for trial, but I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial, or do you want to take that offer?
Can I ask one simple question?
Sure.
I'm just trying to ask, I watched the video of how the case started, and I was the one that was finished with it, sorry.
So that's what a jury's for. If you don't think you're guilty of what they're said, that,
I mean,
then
I can't assault you if I'm already detained.
I don't need to know that. That's what a jury's for.
Yes.
Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has, and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
So,
And just for the record, I've explained this to him. I've shown him several different videos. Some of them are more relevant than others, and he indicates some things that there may be other videos out there that I don't know about. They're not there as far as discovery. He's indicated he wanted to hire Marsha Norman, and I told him you can reject it. If you're not guilty, then don't plead guilty and reject it, and if you can still hire Marsha in the meantime.
Mr. Nichols, is there any other discovery that you anticipate?
I didn't see any in the file from Ms. Volpino, anything else, Your Honor.
Okay.
I know she made the offer. I know that he had got a reduction on the same charge a year ago, so I don't see any reason the offer would change. They did ask for probation this morning. I did not change Ms. Volpino's offer.
Okay. So, Mr. Martin, if you don't want to accept that offer and you want it to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
Yes, ma'am. I just want to ask, I've been trying to get a job and work to see if I can just see if it'll help me out with my time as a trustee.
Okay, none of that matters right now, okay? Because here's what we're not gonna do. We're not gonna put your case on the trial docket so that you think you can get some time under your belt, and then you're gonna plead guilty later, because after today, I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time. Either you did it or you didn't do it, and if you didn't do it, then you can sign that and we'll get a jury to decide, but I don't want you to think you're gonna come back in here later and say, oh, I wanna take that deal, because it's not gonna happen.
Yeah.
All right?
Am I eligible for parole?
I don't know when you're eligible for parole. I don't know how much time you have.
I never had to do this. That's why I'm asking
I know, and that's why Mr. Parker's,
I'll be able to bail.
nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not us. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on.
I've explained to him how much time, based on what he's told me he has, and how much time I think he'll have to do before he's eligible. But again, I told him I can't guarantee that. But if you're not guilty, then don't sign it. You please reject
So
it.
it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial, or you plead guilty and
I'm gonna go ahead on the sign.
sign what?
I'm not guilty.
You can't say you're not guilty and then sign for time. It doesn't work that way. Because what happens,
On an officer?
for obstruction, it's not assault on an officer.
Obstruction, retaliation.
It's obstruction or retaliation, which is different, and there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it,
I wanna go to trial.
okay, sign that for me, rejecting that plea offer then.
Okay, where?
Look, sir, pay attention, sign that.
Okay, where the, that?
Right there, just defending right there.
Okay. I got a hospital bill and I got evidence of free world.
So real quick, hold on, before you go back. Mr. Parker has been appointed to represent you. With your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so I'm going to appoint a new attorney today. They'll be out to see you very soon. Huh?
Can I pick one or y'all?
No, you're going to get whoever's next on our list. If you have whoever's next on the list.
You can hire whoever you want.
You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready, okay?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you.
Now watch this carefully. This is what's called an open plea. She's pleading guilty without a sentencing agreement that is extremely risky. Why? Because she's handing full control of punishment to the judge, and the judge can stack sentences back to back.
Good morning, sir. You're Chase Bro.
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment?
Well, Your Honor.
Mr. Bro, in cause number 22-40132, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 17th of 2022. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And why is there a difference between the rejection and what we've got today?
Your Honor, this is a case that, in all honesty, we shouldn't, I am of the opinion that we shouldn't be using or wasting a jury on unauthorized use of a motor vehicle case. The defendant's taking responsibility, given his criminal history. I think 180 days is sufficient. I'd much rather focus on the rapes, robberies, and murders than try a juvenile case.
I don't disagree. I just think we need to do that when we do those rejections. All right. So do you understand if I follow the agreement that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I'm required to ask everyone that.
I think I'm ready.
State tenders number 1. It's admitted. Is there any evidence that Mr. Bro is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Burbank. All right, good luck to you, sir. Thank you, Mr. Coleman. Thank you, Mr. Burbank. And then you've got Augustus Simon, Mr. Burbank.
And there it is request denied. Judges almost never waive pre-sentence investigations. In repeat theft cases, a PSI report digs into criminal history rehabilitation chances and risk to the public translation. The court wants the full picture before deciding how much time she's facing.
Good morning, sir. Are you Augustus Simon Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Your Honor.
Mr. Simon, in cause number 23, DCCR 1542, you're charged with the first-degree felony offense of murder from September 9th of 2023, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over it with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney, you will be waiving or giving up any right to appeal? So if I take this plea agreement, which is for 40 years in prison, you can't.
It's a cap of 40.
Oh, it's a cap of 40, I'm sorry. So as long as I don't give you more than 40 years, you're stuck with whatever I give you as long as it's 40 or less, and you can't change your mind later. Do you understand?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it also looks like that as part of that agreement, the state is going to dismiss cause number 23, DCCR 1543, which is the tampering with physical evidence. Is that your understanding? So I want to make sure you understand you have an absolute right to have a jury trial. In fact, your case is set for trial for next week. And you could have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right, and again, you're leaving it up to me, and as long as I stay within that plea range of 40 years or less, then you're waiving your right to appeal, and is that what you want to do?
Yes, ma'am.
All right, state tenders number 1.
No objection, state's one.
It's admitted. Is there any evidence that Mr. Simon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Anything that you think is important, get that information to Mr. Burbank and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Excuse, Your Honor.
Yes, sir.
This exchange is tense and super important. The judge is drawing a hard line. You don't get to delay trial just to earn jail credit and then take the deal later. That's a strategy courts see all the time, and she's shutting it down completely.
Thank you. Good morning, ma'am. How are you? Good morning, sir. You're Charles Elam?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will.
Let me get it pulled up correctly here, just a second. All right, Mr. Elam, in cause number 15-22022, I have a motion to revoke your community supervision. Shows that you were placed on probation June 27th of 2016 for the third-degree felony offense of driving while intoxicated, third or more, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation by committing in count 1, by committing the offense of driving while intoxicated third or more, March 7th of 2023 in Chambers County, Texas. And is that true or not true?
True.
And count 2 alleges that you failed to never become intoxicated or under the influence of intoxicating substance, and that you were intoxicated March 7th of 2023. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I have some documents here on the computer that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Elam is not competent?
No, Your Honor.
All right, give me just a second to get this pulled up. I guess this was all done before we were putting in PSIs for me to see.
He's been in custody since 2023. We actually had to bench warrant him because he's been in TDC.
He has.
He was sentenced in Chambers County already to TDC.
Okay.
You have the criminal history, Your Honor?
Yeah, I just kind of wanted to make sure.
This was, he had a DWI third that he got put on probation for and revoked. The offense date of that was 2002.
Okay,
And so that's why I agreed to probation on this one, because there's about a
gotcha.
15-year gap.
Okay. All right, then, Mr. Elam, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Yes.
Good luck to you, sir. You can go back with the bailiff.
And now the stakes jump dramatically. We've gone from probation violations and theft to a first-degree murder plea notice. The plea structure, a 40-year cap. That means the judge can sentence anywhere up to 40 years, but no higher still. That's an enormous amount of discretion in the court's hands.
Edward Miller, Ms. Holmes? Yes. All right, are you Edward Wayne Miller? Can you answer out loud for me? Yes?
Okay.
What's your name?
Okay.
What's your name?
Okay. Okay. All right.
Is there a,
I have debated, and I've told him, I said, if I need to do competency evaluation, then he tells me, he said, oh, no, I'm fine. It's like he switches. So it's like at one moment, he absolutely does not understand anything. Then when I say, okay, let me get him evaluated, then he's like, oh, no, I'm confident. I understand.
well, we're going to do an evaluation. I'm going to reset it. I'm going to, I feel like I have to, just based on that. And so I'm going to delete this paperwork, and we'll have somebody get him evaluated for competency as quickly as possible. You can go back with the bailiff. We're going to have to help me figure it out today, because I tried.
I found out you do this now.
Oh, okay. Good morning, sir. You Christopher Henry James? And Mr. James's case is set for trial to begin with jury selection next Monday, and what is the announcement?
Judge,
State's ready, but Mr. Lewis has discussed it with me also.
Judge, I'm not ready from the defense end, Judge. I have a trial that's going to start Thursday. Supposed to pick a jury Thursday in the 496 in Harris County. Start testimony on Monday.
Okay,
And I anticipate it is going. I don't see it being worked out.
okay. If for some reason it does not, can you be ready?
It would be tough, Judge. There was some additional information I did receive a couple of weeks ago. Well, it became available a couple of weeks ago. Was the rest of the on-top reports and things.
Okay.
Right.
All right, so what I'll do is take that into consideration, and then if something changes, would you let me know on Thursday if for some reason that case works out?
Oh, I will, because actually I'm getting ready to head that way now for pretrial conference there as well.
Okay,
So,
well, yeah, so
I'll
let
you
us know this afternoon. If something happens today and that's gonna go away, and then you would have all week to prepare, then we'll go ahead and I'll number it. Obviously, if you're getting ready for that other one, we'll reset it, but if I have to reset it, Mr. James will reset it as quickly as we can, so that we can get your case tried, okay? All right, yeah, just let us know this afternoon.
No problem.
Thank you.
Thank you, Your Honor.